Hello, everyone. This is Mike Fielding. I'm a partner in Husch Blackwell's Food and Agribusiness Industry Group. I focus my practice on representing lenders dealing with distressed agricultural loans, and I want to extend a very cordial welcome to each of you for attending our webinar today that's going to be discussing hemp lending, preparing for the next commodity crop. This is a really important topic. It's a very fast and evolving topic, and we hope that you find it very beneficial. Now, before we jump in with the meat of the discussion, I need to make a few housekeeping comments. The first is that this is the first in a series of webinars that are focusing on issues that impact the food and agribusiness financing. And at the end of the CLE today, you'll have an opportunity to give some feedback on not only on our presentation, but to offer ideas for future webinars. And we would genuinely appreciate any suggestions or comments that you may have about issues that are important to you for which you would like to see a more in-depth discussion. Now, let me talk real quick about your console, what you see up on the screen. At the bottom of your audience console are multiple application icons for your use during today's program. We're going to highlight these icons for you. If you have any questions during the webcast, please submit your question via the question box. We will try to answer all questions during the webcast today, but if a more detailed answer is needed or if we run out of time, we will answer it later via email. We genuinely appreciate audience participation and candidly encourage you to submit questions. Keeping in mind, of course, that this is educational purposes only, disclaimer, disclaimer, disclaimer with all that. All right. There's also an icon to assist with your viewing preferences. Accordingly, please note that you can expand your slide area by clicking on the maximize icon on the top right of the slide area or by dragging the bottom right corner of the slide area. If you have any technical difficulty, please click on the help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck and additional materials are available in the resource list icon that looks like a folder at the bottom of your screen. This program has been approved for continuing legal education credit in Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, and Texas. Wisconsin credit is pending. And while we're on that, some states, Kansas in particular, require that there be poll questions issued periodically during the presentation just to make sure that you're listening and paying attention. We're actually going to push out the first question right now. And these are just simple generic questions. All you need to do is click a response and then click a submit button, and then you will we'll see audience answers in a moment. So while you're taking the poll, poll question, let me continue on with these housekeeping items. To report your hours in Illinois, Kansas, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. You may download the certificate of attendance from the certificate widget at the completion of today's program. A recording of this webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you. As you can see now from our poll questions, we are predominantly Midwest-based here today, although we have some folks from other parts of the country as well. The good news is our presentation is not going to be limited to just Midwest states, but we are really talking about hemp lending generally. Let me just briefly introduce our speakers that we have today. Joining me is Steve Levine from our Denver office and Lauren Capitini from our Madison, Wisconsin office. Lauren is a member of our Cannabis group and helps financial service clients align their business goals with federal and state regulations. She works closely with clients to meet their unique needs when drafting and reviewing lending and deposit contracts and disclosures, consulting on new product development, reviewing advertisements in various mediums, advising on check fraud matters, and providing general guidance on complex regulatory issues. Steve leads our firm's national cannabis practice. Since 2010, Steve's major focus has been on the burgeoning cannabis industry, where he guides clients through the tangles of shifting regulations governing the sale and use of cannabis in both marijuana and industrial hemp sectors. So, with that introduction and without further ado, I will turn the time over to Steve.
Thank you, Mike. Hope everyone is doing well today, and hopefully today's topic can be maybe a welcome reprieve from the various COVID webinars that I'm sure we all get inundated with on a regular basis. So in sort of presenting this topic, from my perspective, I wanted to kind of set the stage as to really what is cannabis. And, I've been in the space, as Mike said, since 2010. Our firm probably has well over 60 attorneys working on various cannabis-specific matters, and that relates both to marijuana, or at least state legal marijuana, and industrial hemp on a national basis. We are a Chambers recognized firm, and also myself and a upcoming associate are also recognized individually on Chambers. So really appreciate this opportunity to speak with everybody today. And really, when I think of what is cannabis, cannabis is really Cannabis sativa, and that's just really a plant. And that plant has been sort of delineated into two sort of legal constructs that really have a lot of tangled webs associated with those, with the various words. So we have industrial hemp, which is primarily what we're going to be talking about today, but I think it's important to also identify what is marijuana, because it is the exact same plant, and really the difference between the two is as simple as the legal definition, and can be as problematic as when you think you might have industrial hemp growing on a property that you might be, that a borrower might be producing on, can be turned into marijuana very quickly, which, as a reminder, still remains federally illegal as a Schedule I drug under the Controlled Substances Act, even though to date well over 30 states have legalized the use, distribution, sale of medical and adult use marijuana. With the 2018 Farm Bill, effectively descheduled industrial hemp and removed it from the purview of the CSA. Really, industrial hemp, and I'll refer to it generally as hemp, is still subject to state and federal regulations. And so what I think is important is, again, to understand what is marijuana. So I'm just going to read the definition to kind of set the stage of how convoluted a lot of this stuff can really be. And so marijuana is defined as all parts of the plant, Cannabis sativa L, whether growing or not, the seeds thereof, the resin extracted from any part of such plant, and every compound, manufacture, salt, derivative, mixture, or preparation of such plant, its seeds or resin. And then there's a carve-out. Such terms do not include the mature stalks of the plant, fiber produced from such stalks, oil or cake made from seeds of such plant, and any other compound, manufacture, salt, derivative, mixture, or preparation of such mature stalks, except for resin extracted therefrom, fiber, oil, cake, and sterilized seed of such plant, which is incapable of germination. So, okay, what does all that mean? Functionally, the flowering part of the Cannabis sativa plant is really what marijuana is, and including any sort of oils that are extracted from the flower part of the plant. Traditionally, the stalk, stem, and ungerminated seed from Cannabis sativa has been carved out from the definition of marijuana, and why we have seen textiles such as rope, clothing, rugs, those kinds of things that have been imported legally into the United States for well over 30 years. Hemp was defined via the 2018 Farm Bill, which excluded Cannabis sativa containing less than 0.3% of THC on a dry weight basis. So what is industrial hemp? It's obviously not marijuana. It's been excluded from the definition of marijuana in the Controlled Substances Act. And really it comes down to that 0.3% THC on a dry weight basis. Industrial hemp is not psychoactive. It doesn't contain the psychoactive components, which is predominantly THC from Cannabis sativa. And really, it's a specialty crop. It's something that can be used in a lot of different applications. There is a lot of interest in it from not just what I think predominantly what most people think of as CBD, but there are a lot of other interesting applications related to industrial hemp. Fibrous textiles, as I talked about earlier, grain and feed for livestock. Oil is really pressed from the seed of the plant. Can also be pressed from the flower of the plant as well. That's high in omega-3 and 6, high in protein, a lot of medicinal value. Still needs to be a lot of science that comes out of that, but there's a lot of promising things coming from it. Bioplastics, obviously recyclable materials, have really become something that we all need to be thinking about collectively. For example, there's a push in the car industry to replace all plastic interior components with types of vegetative plastics, and that can sometimes come from industrial hemp. They can also come from other plants as well, but those vegetative plastics, one, are biodegradable, but also upon impact tend to sort of dissipate as opposed to shredding and creating more harm to the individuals in the car. There's also, the plant is very fibrous, and so it's used in construction to make what's referred to as hempcrete, and is also a very good insulation material, and so has been used for low-income housing in developing worlds, and is also being used in the United States as well. CBD, obviously that's a big one everyone knows about, dietary supplements, drinks, lotions, vaping, etc. There's all sorts of products out there, some that are problematic, some maybe have some sort of medicinal value, but generally the verdict is still out on CBD itself. There's a whole slew of legal requirements. We're obviously not going to be able to get into great detail on each one of these. Here is just really a sampling of the varying things that, one, if they're going to be participating in the industry, need to be thinking about. As I said, it's cannabis sativa is just a plant, and the legal construct of marijuana and hemp you need to be very cognizant of how close those definitions are and how very close the plant can automatically turn into something that is very much a federally illegal product. There's a slew of marijuana state laws. Hemp state laws are also very different on a state-by-state basis. There's no unique state laws. We obviously have the 2014 Farm Bill and the 2018 Farm Bill, which we'll describe in a little bit more detail later, because obviously that has a lot of impact on the industrial hemp regime. The 0.3% requirement, which we've talked about a little bit, we'll get in a little bit more detail on that in ongoing compliance in the USDA program. So really, just briefly, and Lauren will get into a little bit more detail on the sort of what the 2014 Farm Bill and 2018 Farm Bill really created. But functionally, the 2014 Farm Bill created our definition that we're currently using, and also authorized institutions of higher learning and departments of agriculture at the state level to create pilot programs. These are really just for research activities only. However, most states extended their laws to be much more liberal in their view of what the 2014 Farm Bill put into place, and is really why you saw a big rush of people commercializing hemp, even though it's not consistent with the 2014 Farm Bill. 2018 Farm Bill was really when we've now removed the definition of hemp from the Controlled Substances Act, and now it has become decriminalized, and is really what we view as an agriculture commodity. The USDA, who's the sort of governing body for the cultivation of hemp, has gone through and developed regulations. Those regulations provide for testing, licensing, and sort of the slew of rules and regulations, which we'll describe in a little bit more detail later, of how someone goes about getting approved from a USDA perspective. The USDA has to approve states' plans. So as of June 1, I've listed the existing states that have been approved. If a state that you're in or looking at is not on this list, that means they're not compliant with the 2018 Farm Bill. And so that has pretty broad implications, and I think a nuance that is sometimes missed with all of this is that the regulations are new, things are still getting put into place, and there's a lot of technicalities of people operating in the space that are likely not consistent or compliant with the 2018 Farm Bill. The other states that are in process, so some of the bigger states you might see missing here, Colorado and Kentucky, as an example, they're in the process of either getting states plans approved or choosing to not get something approved now because they view their state plan as being much more operational for how the hemp program is working in their respective states. Here's a just quick little map of sort of how many states actually authorize industrial hemp. For the 2018 Farm Bill, states can opt out and can expressly prohibit industrial hemp, which is important to understand. Obviously, we have Idaho and Mississippi here as states listed that have not approved any form of industrial hemp being allowed to be cultivated in those states. So that sort of sets the stage, and now really what I think is critical to any sort of new industry, and especially for lots of folks on the phone who might be in the banking industry, insurance industry, or even the legal industry, is what are really the main issues that the industry participants that you might be servicing or have as clients or have as borrowers, what are those macro industry issues? And then how can you, one, identify what those issues are, and then to the extent you're going to engage in this industry, which is what Lauren's going to talk about from a due diligence and risk analysis perspective, is I think critical to knowing whether or not this is the time to participate in this industry or not. And so when I sort of put down a few bullets of what I think are those key issues, I've listed them here. So we have seed, farming know-how, regulatory, financing, and insurance. Seed really references genetics, and so this is not a conversation for us to discuss about actual seed genetics, but I think it's just so you're aware, genetics are not very consistent. It's still a plant that science has not developed a lot of information about. It's not like you can go to the Monsantos of the world and buy seed that if you planted at your particular longitude and latitude, you give it X water, X days of sunshine, it's going to produce X. That doesn't exist yet, and so there's lots of inconsistencies. Genetics that are grown in Colorado versus grown in Kentucky can yield a very, very different plant. And again, going back to the definition of marijuana, can result in somebody growing marijuana as opposed to industrial hemp. And that leads into know-how. Still developing that, growing on an industrial scale. It takes precision ag, takes science, takes time, takes years to really develop and have a consistent product. We'll get in more detail about the regulatory and financing and insurance to follow. So next is really sort of the numerous rules and regulations that apply to hemp cultivation. We obviously have the varying state laws, the USDA rules that we talked about, and ultimately we have the FDA input, which relates more towards finished products. The original pilot program was started back in 2014, and now we're really operating on the 2018 Farm Bill, but there's still allowances for state participants and states to opt to continue to be operating under the 2014 Farm Bill. So we get to USDA licensing. In order to produce hemp, a farmer must first be licensed or authorized under a state or tribal hemp program or through the USDA hemp program. If a state desires to have a regulatory authority, they must submit that plan that I spoke about earlier. States that have already submitted the plan will be given a chance to reaffirm the plan if they want the USDA to evaluate, or they can submit a new plan if desired. The rules really allow the USDA to regulate hemp production in states. where it's been legalized. Obviously, if no state plan has been approved, they cannot operate under the 2018 Farm Bill. Once a license application has been approved, USDA will issue the license. As stated before, several states have been approved. It should be noted that a farmer cannot receive a hemp production license from a state if they've been convicted of a felony related to a controlled substance in the last 10 years. In addition to the licensing component, the land information must also be submitted to the appropriate state or tribe. Licensed farmers are required to report their crop acreage to the Farm Service Agency. This is really the ability to allow USDA and varying stakeholders to have a better idea of how much hemp is actually planted and grown in the United States during any particular harvest cycle. One of the sort of big rubs, I think, for the industry is testing. It's very inconsistent. There's potential for THC, for a test to result in the THC concentration coming above that 0.3% threshold. And so really the stakeholders were hoping to get some regulations that would clarify exactly how this testing would actually occur. However, there's no uniformity over across states in how the crop would be tested. Some states, for example, test the top 8 inches of the flowering plant. Some test the top 6 inches of that plant. So there's inconsistency of how to build a statistically significant sample of a farmer's crop. These regulations require the crop to be tested within 15 days, but there's still confusion around this 15 days. For example, if a sample is pulled 15 days before an anticipated harvest, would the harvest be allowed if there's a backlog at the testing laboratory and the results are not back in time? There's no clarity on that. Really these testing procedures have a lot to be desired. There's a lot of, unfortunately, not a lot of labs available. Testing procedures need to be completed by a drug enforcement agency administration registered laboratory. So generally DEA laboratories are testing all sorts of very complex drugs and otherwise, in that they might just not want to do this new industry. So the availability for testing has been pretty light. Then there's violations. And so these new rules did set forth the fact that a farmer may unintentionally produce a crop that tests over the limit despite their efforts to produce a crop that complies with federal law. The rule really determines that a producer does not commit a negligent violation if they produce plants that exceed the acceptable hemp THC level, as long as they're using reasonable efforts to grow the plant and do not test at more than 0.5% THC. Will not be considered negligent. The crop is still, unfortunately, considered a controlled substance at that point, again, going back to my definition of marijuana that I started out with, and must be disposed. So you could have a scenario where a test comes back and a testing that is maybe inconsistent or inaccurate results in something of having being above that 0.3% THC on a dry weight basis, and a farmer's entire crop needs to be destroyed. That obviously has huge implications for the operator, the farmer. That has implications for the lender as well on the property, and ultimately the downstream contracts and production as well. So there's lots of litigation around a lot of this, and in a pretty challenging space. The 2019 harvest resulted in a lot of inconsistent product, a lot of farmers that had to destroy product and either produce product that didn't have the CBD content that was expected, or grew something that was not up to spec for the downstream producers. So I'll pivot a little bit to, so next steps are USDA. So obviously there needs to be some sort of seed certification, that there needs to be some commercialization of actual seed products to have consistency in the product, and the marketplace can have assurances that what's being grown is actually hemp. better testing regulations, better flexibility regarding THC limits. There's actually ways to remediate certain products that have higher amounts of THC in them. You can extract THC from products. So there's some hope that there's some guidance in new laws allowing for that type of process, so people don't have to just completely destroy their commodity. So next is really FDA. FDA has been sort of given the oar to deal with the burgeoning CBD market. I put a few quotes in here. I'm not going to read them to everybody, but I think it's just illustrative of sort of the hands-off approach, frankly, that the FDA has taken. Obviously, they're concerned about public health and safety, but because there's so much, I think, lack of knowledge and inconsistency between state and federal law, the FDA has functionally felt as though that their hands have been tied and have not really given a lot of guidance to the marketplace as to how people should be operating and selling CBD out to consumers. And so what I thought might be helpful would be to sort of go back to a very recent warning letters that the FDA issued in November of 2019, and kind of talk about those a little bit, because I think it gives a good context as to the FDA's position and what they're trying to prevent. But ultimately, these are really just warning letters, and they haven't taken many other steps to curtail the industry. So these letters were issued to companies for marketing various CBD products. They identified in the warning law, they span conventional foods, dietary supplements, animal products. The FDA made specific mention in these warning letters about statements regarding the use of CBD products in infants and children. Really what they were getting at is that CBD is not GRAS, which means generally recognized as safe. I'll point out that oil pressed from non-germinated seeds is considered a GRAS qualified product. So you might see other products, whether they're ungerminated seeds or hemp oil at your local grocery store, that actually have been approved as GRAS. So it's a little bit different than what CBD is. What came out of this was, they still have many unanswered questions about the gaps of CBD toxicity, and that the available data raises concerns about potential harm from CBD. They've updated their specific safety concerns to include potential liver injury, interactions with other drugs, drowsiness, and changes in mood. They also have concerns about studies in animals. Those studies in animals have reduced sexual behavior, testosterone levels, and there's really questions about the cumulative use of CBD and about CBD's impacts on vulnerable populations such as children and pregnant or breastfeeding women. These letters really related, continued concerns about the use of CBD. The warning letters cite, that the claims that were being made were associated with serious diseases. So, this cures cancer, this cures your opiate addiction type of claims. However, there was one letter that appeared to be aimed more at veterinarian claims and or human structure function claims. So it's a little bit of a change in perspective from the other previous warning letters prior to November of 2019, and demonstrating the FDA's raised concerns of the use of CBD. In particular, animal food, conventional food, again, CBD is not GRAS, dietary supplements, and products marketed for infants and children. Went too far. And then the last sort of more recent update with respect to the FDA, March of 2020, they released a statement about efforts being taken to educate the public of these various risks. There continue to be concern that people view CBD as a product that can't hurt them. And really, just so everyone is aware, aside from one prescription drug approved by the FDA, which treats a very specific severe pediatric epilepsy disorder, no CBD has been evaluated or approved by the FDA. So they continue to sort of punt on any sort of responsibility for regulating this. I think functionally they feel as though they don't have enough information to regulate it and are really looking to Congress to actually develop some laws to tell them how to regulate it itself. They've also reopened their public docket to allow for more submissions of scientific data, and hopefully people in the industry will take heart to that and start contributing additional scientific data that can help inform the FDA that either some of these products are safe or maybe that some of these products are actually unsafe, that propose a risk to public health and safety. The next concerns industry participants have is obviously, on the banking and insurance side. FinCEN has given some guidance, very clear guidance in December of 2019, because hemp is no longer a Schedule I controlled substance, that banks are not required to, file a SAR on customers solely because they're engaged in the cultivation of hemp, so long as they're operating in accordance with applicable laws and regulations. And that's great, but the unfortunate part about that is that I've already kind of gone through as quickly as possible here, is that there's still a lot of uncertainty, a lot of lack of regulation, a lot of confusion about what states are actually operating compliant or not with the 2018 Farm Bill. And so I think banks are continue to face challenges in determining whether they can, have depository accounts or even lend in the space because of these challenges that their hemp-related customers are likely facing. Lauren will describe in a little bit more detail here shortly of the process and due diligence, credit approval, and risk analysis that market participants can look at when looking to lend and or provide depository accounts to hemp-related customers in the space. There is really, on the regulatory side with this is that's, so now it's been removed as a controlled substance, and then it's the compliance piece. Monitoring these thresholds, identifying whether a individual is licensed by the state or not. There's transportation issues. So there's been numerous cases of individuals transporting large semis of industrial hemp from Oregon to Colorado, for example, and they drove through Idaho. And if you recall several slides back, Idaho has expressly prohibited hemp in their state. So there have been instances of semis being pulled over and the drivers arrested for carrying, guess what, marijuana, because Idaho also similarly doesn't allow for any sort of medical or recreational state legal marijuana. And it's created a lot of sort of chaos for the industry a little bit on how to properly transport that product, and ultimately what's the risk profile for that as well. And this comes to the product liability piece. Ultimately there is, on the insurance side, there are definitely private options. There are several state and federal programs for natural disaster crop insurance. So there are definitely options out there. On the private side, there's, depending on the group you're speaking with, there can be proper insurance policies. I've seen a lot of policies that have lots of carve-outs, in particular non-compliance with law type carve-outs, which are in particularly very challenging in this industry given the uncertainty of state compliance and federal compliance. And so, really revisiting contracts and ensuring that there's compliance there for these market participants. So with that, I'll turn it over to Lauren and let her speak to some of the process points that an institution can think about when trying to participate in this space.
Great. Thanks so much, Steve, and good afternoon, everyone. Thanks again for joining us. So as Steve mentioned, I'll be guiding us through this due diligence section, which I know weighs heavily on your minds as lenders. But before we do that, we have another poll question to get to. So specifically, push to audience. We're asking you, have you engaged in any lending or have you opened deposit accounts with persons engaging in hemp-related activities? So we'll give you a minute to answer yes or no, and then we will head to the next slide to see our poll results. No, 100%. Wow. Okay, well, I'm glad you're all joining us then today. So without further ado, let's move on to due diligence. So as many of you on this call are aware, your lenders or your financial institutions, banks, credit unions, who have obligations under the Bank Secrecy Act, anti-money laundering laws. You have to do this due diligence. Specifically, you have to know your customer at the outset of the transaction. And this is on the loan side and the deposit side, so both types of accounts. You have to establish a customer risk profile, which requires understanding what types of activities is your customer engaging in as a business. Who is this individual or who is this business? And you have the responsibility to conduct ongoing monitoring. As part of your BSA compliance program, you need to confirm that what's coming in and out of the account, the activities that are occurring on that account, are consistent with what you would expect for that type of account. And then, of course, as Steve mentioned and alluded to, you have suspicious activity reporting responsibilities along with CTR responsibilities. And so certainly in this space, those engaging in hemp-related activities certainly can become quite complex from a due diligence standpoint. Steve did an excellent job of laying out the extraordinarily complicated mishmash of federal and state laws and regulations, the role that USDA is currently playing, the interaction between the 2014 and the 2018 Farm Bill, how quickly you can go from having a properly grown hemp to having a hot crop and operating outside of applicable laws. And it's incredibly important to get this due diligence piece right because it can easily devolve into not only just technical violations of state hemp requirements, but it could, to devolve into, hey, you've got a farmer who you bank who is growing marijuana on their property, and now you've got a big problem. So to that end, it's important to get this piece right, and there has been quite a bit of confusion on the lending side as to what exactly this due diligence requires. And I think we've got at least some component pieces in place that we can talk to today. More to come, we expect. So at account opening, of course, you must know who your customer is and do your due diligence, consistent with your BSA compliance program to ensure that that customer is not engaging in unlawful activities or activities that present just too high of a risk for your institution. And that you would need to establish in your policies and procedures, which we'll talk about in a little bit. And then after account opening, of course, you have to maintain consistency with your due diligence program, with your BSL-AML compliance program to ensure you're properly monitoring that account on an ongoing basis. So what does that mean in practice? Okay, so that's the law, but what do we actually do about this? So when you have a business come in or an individual come in, you need to ask the right level of questions. That is the first component of this. You need to ask, are you engaging in hemp-related activities? that will help you establish the entire component piece of due diligence for this business. So, are you engaging in hemp-related activities? If the answer is yes, you need to dig further. You need to understand what the types of activities this individual is engaging in, or this business is engaging in. Are they growers? Are they processors? Are they retailers? What types of activities are they involved in? And that will help you gauge what level of risk this customer presents to you. Furthermore, you need to ensure that those customers are acting consistently with state laws in which they're acting pursuant to. So, if you have a farmer in the state of Wisconsin, for example, who is simply just growing and is looking for maybe an equipment loan, for example, that's going to be potentially less risky than a retailer who is selling in multiple states, because you're really only dealing with the state of Wisconsin's hemp program, for example. And Steve had kind of laid out the complications that you have when you've got right now 48 different states acting under different versions of different state laws pertaining to hemp activities. So certainly complicated to ascertain whether or not a customer is acting consistently with state law when you've got 48 state laws to address. Now, typically what that will look like, if you're wanting to confirm that an individual is acting consistently with the states in which they're operating, is you're going to gather information that gives you that peace of mind. So, for example, we know that there's licensure requirements at every state and every state's program. Get a copy of the license. Typically you'll see planting reports that will need to get filed with the regulatory body in the state. Do you need to get a copy of the planting report? Do you want your customer to advise you or if their crop tests hot and they're now out of compliance with state law? All these things kind of go into what level of risk you have, whether or not you're going to bank certain types of customers, and then you would ask for the right level of information that you need to ascertain whether or not you would want this individual as your customer. Now, how do you get that information? Typically, what we have seen is you ask the question on an application or give a separate form where a business would indicate whether or not they're engaging in hemp-related activities, and then a level of questions that follow thereafter pertaining to what types of activities or whatever information that you need to understand from that customer to determine whether or not they're going to meet your requirements under your BSA AML compliance program. So, in the past, we've seen forms vendors or auditors provide these types of questionnaires. Your state trade association may offer one as well. And certainly, if that's not the case, your lawyers can draft them. We've done our fair share of drafting. So then once you obtain this answers to this level of information to your satisfaction from these potential customers, you need to determine if their answers meet your compliance program. So have they set out activities which, in accordance with your program, you have decided you feel comfortable making a loan to, or in the deposit account context, opening a deposit account for. And then you would want to set that risk profile accordingly. So, we frequently get asked the question, does that mean that you're setting all businesses engaged in hemp-related activities as a high-risk customer? No, not necessarily, but certainly you can. It's just whatever you feel most comfortable with as it relates to your compliance program. And of course, as I mentioned and as Steve alluded to earlier, this applies, the same if you're making a loan or if you're opening a deposit account for a customer. You could have a situation where you've got, a customer working with a non-traditional lender and you've got funds flowing through the account. You still want to ask those same level of questions. You still want to do your due diligence to understand what types of hemp-related activities they're engaging in. So when you're conducting, we've gone from, all right, you've done the due diligence at the outset of the transaction, and now you're in the ongoing monitoring. What do you have to do? So you need to monitor consistent with that customer's risk profile that you established at the outset of the transaction, and monitor consistent with your compliance program. And that means filing SARs as appropriate. And here I think the key phrase is as appropriate. As Steve mentioned, there was 2019 FinCEN guidance issued, I believe, in December of 2019 that provided some real helpful guidance to financial institutions who are banking hemp-related customers. And prior to the 2019 guidance, there was quite a bit of reluctance in the industry to get involved from a lending or deposit standpoint with some of these borrowers because there was such a lack of clarity at the federal level as to what your responsibilities were. As the regulators kept telling us, follow the 2014 FinCEN guidance related to banking marijuana-related businesses. And we kept saying, but, as of 2018, the 2018 Farm Bill, hemp has been removed from the controlled substances list and differentiated from marijuana. So, what do we need to do? And it was just not clear. So the 2019 guidance was very welcome. And as Steve mentioned, what the guidance says is you now, for hemp-related activities, you do not need to file a SAR solely because a customer is engaging in a hemp-related activity. You file SARs as the activity dictates, which means that you monitor the account for unusual activity. And we've consistently had questions of, well, what is that unusual activity? And so to that end, I wanted to ask Steve if you wouldn't mind jumping in and kind of giving us your impression of the overall typical activity you would see in an account.
Yeah, so I mean, being in the cannabis space for 10 years, everything seems unusual to me. But I think for our purposes here, unusual, I would think of large deposits being made by the customer prior to harvest or during harvest, during the growing cycle where there's really no income being generated until the harvest has actually occurred. So if you had a customer making regular cash deposits of $200,000 or $300,000 a month through the months of February through August, that might be somewhat unusual unless they had a large crop the previous year and were able to sell off crop that had been stored over time. Again, the industry is still in its nascent sort of development, and so I think it's going to be a little challenging to kind of make determinations as to what really is unusual, but that speaks to the due diligence and understanding what your customer is on the front end so you can properly monitor and make that determination.
Thanks, Dave. So what do we take away from this? I think it's really critical to update your policies and procedures, your compliance program, to reflect how you're going to manage this. So what types of businesses are you comfortable engaging in hemp-related activities with? I mentioned that local grower or that local farmer maybe presenting less risk to you than someone that's operating in multiple states. Doesn't mean you can't do it. Just think about that risk tolerance. You also need to think about what information do you need to gather? What are the questions that you need to ask to gather the information that you need to make the decisions as to whether or not these customers fit within your parameters. And then furthermore, what level of risk will you assign to these specific customers? And then finally, looking at what are those flags for unusual activity, which, is challenging, but, the best that we can do at this point. So one question, again, that's recently or has frequently come up is, what do you do if you discover that an existing customer is using a loan or line proceeds for hemp-related activities? And I think our response is always, well, clearly you're going to get that information from somewhere. How did this come to your attention? What is the information that you know? Assess that risk. And then if you believe that there's risk, ask questions. So, maybe it's providing the questionnaire to that customer at that point in time, getting a certification from that customer as to what their activities are, potentially revising their risk profile as needed. And finally, really just looking to their documents. Can you call the loan in default? So if this is a lending arrangement, do your default provisions allow for that? And if so, do you want to call the loan in default? So really, it's the typical lawyer response. It depends. It will absolutely depend here on the information that you have and the facts that you gather. So again, just conducting due diligence at the point in time that comes to your attention. And then just to mention a few other risks, and I think Steve had done a good job of kind of going over a lot of these.
Let me interject really quick because we did have a question.
Sure.
Lauren, this is Mike. Let me interject with a question that one of our listeners raised. The question was, when we were talking about the payment profile, the question is, would the payment profile change as futures are contracted or as the market develops? So if you have futures being sold for the product, is that going to impact your payment profile for reporting purposes?
And Steve, that might be a better question for you, actually. If you have, were you able to hear that?
As far as the futures contract as the market is developed, I mean, look, for a futures contract, yes, I think the profile could change if there's consistency with what the as those futures develop. Then I think we'd have more clarity as to what they look like. But I don't think there's a true futures market yet because the output for all this biomass is still kind of yet to be determined, and the 2019 harvest cycle really resulted in an overproduction in certain areas and underproduction because of failed crops. So I think, yes, I think that will change as time develops.
Thanks, Steve. Thanks, Mike, for interjecting. Just to look at a couple of additional risks that we had highlighted earlier too, recognizing that, there can be some risk to taking the crop or the land as security, for example. Hemp is still in its infancy. We're still learning about how climate affects yield, how it affects the crop, how it makes it go hot, why it doesn't in some instances. We're also, there's a high potential return on investment here, but the cost per acre can be high. And so, there's still a lot of differences between, who's growing what types of seeds are being used, and what impact that can have on your yield and your return on investment. Hemp is incredibly labor intensive. And you just don't know what your yields might be yet. And then furthermore, on the, we have highlighted here some risk of disease. The EPA has approved, at this point, only 10 pesticides for use on hemp. Now, that's relatively modest, and we know that more are to come. But right now, it's 10, so potential risk there. And Steve had really talked about the seeds and the importance of genetics. And the other real important component here is if your crop goes hot, and in some states you have to test hot, above the threshold at least a couple of times, your crop has to be destroyed. So, that could affect your security surely. And then moving on to crop insurance, Steve had alluded to this as well, but there are a couple of, certainly there are private potential options, but there is a risk management agency option for multi-peril crop insurance. These are relatively recent, as well as a farm service agency option. Now, important to point out that a covered loss, would not include, for example, destruction of a hot crop, or the inability to market the hemp. And there's certainly other important, losses that would not be covered. So with that, I believe I am sending it back over to Steve.
Yes. Thank you, Lauren. I think we only have a few minutes left, so I'm going to kind of just do a real high level on the financing documents and turn over to Mike to speak briefly to the security interests. I think when thinking about financing documents, there's, I think, maybe two schools of thought. One is, well, why do we need to change anything? This is a crop that's now federally legal. Let's keep our existing loan suite in place, keep the existing reps and warranties regarding compliance with law. There's other school of thought where, we need to more customize our existing financing documents. Maybe there's additional affirmative covenants, for example, that are attached as an addenda to your form documents for testing, notification of testing, ongoing certification that they're a licensed business to ensure that you're not lending, or at least you don't have knowledge that you're lending to a customer that is engaged in a federally illegal activity. The types of reps and warranties, someone I've already talked about, samples taken, the hot crop concern, indemnity type risks, compliance with other, specific USDA and FDA rules. I think I'm probably more on the fence of staying consistent with your existing loan documents, and really adding an addenda to address the unique situation for whoever that particular customer is, and requiring some affirmative covenants so that the lender's not really sort of putting its head in the sand, and to the extent there is a real issue of somebody growing marijuana on property that you have a security interest in. Sort of other factors, specialty equipment, the kind of the terms, guarantees, defaults, a lot of those are sort of business considerations, and will sort of be dependent upon what the particular document is. And so, Mike, maybe you can touch on briefly on securities interests, since we only got about a couple of minutes left.
Yeah, absolutely, Steve. So really quick, I think let me just give a very high-level overview first off. Somebody listening to this will say, excuse me, why on earth would we loan into a situation like this? And that is a great question, because as you have heard, there is a lot of uncertainty in dealing with the hemp, and that uncertainty comes from an evolving legal framework. There are numerous questions about production, and then candidly, there's going to be a lot of questions about marketing and how you sell and get this out into the marketplace. And then once it's out there, what sort of bogeys exist as far as lawsuits coming back on your producer. So that's the first big takeaway. It is very uncertain. But I think the other big takeaway to remember is that this industry is not going away. As the legal framework evolves, as things get more permissible, so to speak, you will see increased industry participants. And so the question is, how do we go about doing that? I think in thinking, going through that process, it is critical for lenders to really think about the entire loan life cycle. So obviously you start with your basics, your security agreement, your UCC filings, your Food Security Act notices. We need to keep in mind that this is a farm product, and so it should fall under the Food Security Act, which requires that you not only put your UCC notices out there, but if you as a lender are looking to get paid, you need to be issuing those notices at least once a year, and so that you protect yourself. And the problem that we have is with such a young, evolving market, a practical problem that you have is how do you or who do you send these notices to? I think when you look at this kind of in a grand scale or grand scheme of things, what this does, at least in given the infancy of the market, this really emphasizes the need to have strong underwriting at the beginning as far as the lender, but then two, there needs to be a lot more proactive involvement with your loan officer in communicating issues, finding out information, and then monitoring or security basis that you have here in the product. Then you get into the big question, right? We think about the loan life cycle, and then you say, well, what happens if this whole loan goes south? And I think the real risk is that lenders may find themselves being what I call a glorified unsecured creditor. And by that, I mean, do you get into a situation where, yes, you have remedies under the UCC, yes, you have the ability to come in and take possession, but does your bank really want to take possession of this collateral? That's a really difficult question, especially if you don't know what the THC level is. And then the question is, so if we do not want to take possession of the collateral, what do we do? Well, there's obviously the option of getting a receiver appointed, and then have a receiver who becomes kind of this intermediary under a court order who would take charge and liquidate the collateral. Certainly that provides insulation for a bank from liability, but at the same time, the question is going to be, can you find a receiver who is both competent enough to know what to do here and who's going to be have the applicable licenses and authorizations from state regulatory authorities to properly dispose of this? Again, we're discussing this issue in a very high-level framework, and the difficulty there is that when you start moving or looking into answering these questions, you absolutely have to do this on a state-by-state basis because the laws differ so much on a state-by-state basis. Now, there is one question about federal bankruptcy eligibility. Clearly, if you are a marijuana producer, you're not going to be eligible because that's still a controlled substance. However, with hemp now being legal, there is going to be eligibility for bankruptcy protection. And so when you are, again, factoring in the remedies and trying to price this loan and figure out what you're going to do, you need to take that into consideration. Now, we are at the top of the hour, actually past the top of the hour, so we've got to get this last poll question in. I'll post this up here very quickly. I'll let you answer that. And while you are putting those points in, let me add these final closing comments. We genuinely appreciate you joining us here today. We hope the information that we've provided has been helpful. If you have not already done so, please click on the survey icon at the bottom of your screen to complete our short survey. Your feedback assists us in providing quality future programs. And in that regard, I would want to point out that, again, this is a part of this ongoing series discussing important financing issues for the food and agribusiness industry. And if you have particular topics that are relevant and important to you, we genuinely welcome your feedback in that regard. As a reminder, this program has been approved for Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, and Texas continuing legal education. Wisconsin credit is pending. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you. This concludes our webinar. Thank you very much.